The Robert Menendez corruption trial has been in recess for the past couple of days because of a Jewish holiday. Happy Sukkot, everybody. When it resumes next week, the big question will remain, did the New Jersey senator's favors for his co-friend and co-defendant, Dr. Solomon Melgen, constitute corruption? Dominic recently sat down with prominent criminal defense attorney Lawrence Lustberg to get his take on this.
Okay, Counselor, the Skelos conviction overturned just last week. What does that mean for Mr. Menendez?
Skelos is the most recent in a line of cases of which the most recent Supreme Court case is the McDonald case that makes very clear that we do not criminalize actions by government officials very lightly. In fact, there has to be something called an official act. And an official act means a formal exercise of power. Here, and the court makes this 100% clear in Skelos, the actions that Senator Menendez is led to have taken have to do with setting up meetings, talking to officials, and expressing support for certain policies. Those are specifically mentioned in Skelos as the kinds of things that are not official acts and therefore cannot be the subject of a bribery conviction. So Skelos really makes 100% clear that there is no legitimate legal theory here upon which Senator Menendez can be prosecuted for bribery.
So when Senator Menendez arranges a meeting with the State Department, when Senator Menendez threatens a Senate hearing on Melgen's behalf, when he takes all these types of actions over Melgen's contract in the Dominican Republic, that's not an official action?
No, it isn't. And in fact, in Skelos, they point to the type of evidence that can give rise to a corruption conviction. There has to be two things. There has to be an official action, a formal exercise of power. So if they could show that Senator Menendez exercised his duties as a senator, that is, he voted, for example, as a result of having received certain benefits, then they would have a conviction. There has to be a quid pro quo. There has to be an exchange for an official action for some sort of benefit. Here they've shown some benefits, but they haven't shown an official action at all, let alone a connection between the actions that Senator Menendez took and the benefits he received from someone who, after all, was a friend.
Dom, you got the feeling that Lustberg doesn't think that Menendez is going to be convicted.
Well, he may be onto something based on it may defy public logic. The public may look at this and say this is an open and shut case of alleged corruption. But when it gets to the appellate court, and if Mr. Menendez, let me backtrack. The judge, when the prosecution is done, could rule on Abby Lowe's motion, rechange his position, and dismiss all charges with no defense putting a case forward. So it may even be over before it's over, before it even gets to the jury. Now, that's highly unlikely. The judge will probably punt, and give it to the jury. But I tip my hat to this jury, Andrew. It's tough to sit in that courtroom all day long listening to testimony about God knows what and minutia of details for the average person, and they're doing a good job listening to it.
Here's where I think the disconnect comes in for most people who are at home watching, and certainly for you and I, because we deal with politicians all the time. There's a lot of official actions that take place that have nothing to do with official acts. You're a U.S. Senator. You're a U.S. Senator 24/7, and your name and your reputation carries a whole lot of weight. Same if you're a mayor or majority leader in the state Senate or the state assembly. I mean, you carry a lot of weight even if you're not casting a vote or signing a contract. And yet legally there's this disconnect that all those other times don't count towards those official acts.
Well, excellent point. And based on the definition the counsel just made and what others have made, and frankly what the Supreme Court has ruled in McDonald, which narrows the definition of corruption, how will you ever get a conviction? Let's say you and I are politicians. We are not stupid enough to put the bribery in writing and say, I'm going to do this. We're going to do a wink, wink, and a nod, nod, and I'm going to advocate on your behalf, and you're going to make the payoff.
I think you've hit on something there, Dominic, because it sounds like the Supreme Court has set the bar so low so that only the stupidest politicians can possibly be caught for corruption.
You have got to be as dumb as a rock based under the Supreme Court definition to get for corruption. Now, that's not to indicate that Mr. Menendez has committed a crime. He says he hasn't done anything wrong. Dr. Melgen says he hasn't done anything wrong. Dr. Melgen, though, has been convicted of Medicare fraud in Florida. Now, keep this in mind. It's all of this comes down to, Andrew, it's about an eye medication, right? So the good doctor, $8.9 million. The good doctor, you're supposed to use the vial one time and then throw it out because of the risk of infection. The good doctor claiming that he didn't understand the argument of wasting medicine, which is a legitimate argument. The good doctor would take that one vial and treat 3 to 4 patients and, of course, bill Medicare separately for each one.
When I think of
at $2,000 a pop.
It's a great way to make money until you get caught. When I think of all the politicians
and the senator advocated for Medicare to change the policy for them to get paid. But go ahead.
When I think of all the politicians you and I have covered who are sitting in either state or federal prison right now, they must be looking at the Supreme Court like, where was this ruling when I was on trial?
Good point. I know we're short on time because those that are like Malcolm Smith and so that are sitting in jail right now. Okay, so why are they in prison, but Sheldon Silver and Dean Scullo's convictions, could it be because they were the most powerful officials in the state?
Wrong crime, wrong time. All right, let's move on to a disturbing discovery at Westchester Community College. Members or supporters of the white supremacist hate group Identity Europa placed what appeared to be recruitment posters on campus bulletin boards in common areas on the campus. Now, the group has been doing this on campuses around the nation and tweeting out messages to show their recruitment efforts spreading. WCC is a SUNY school, which means the state has oversight, though the county government approves the school's budget and meets regularly with union and management members. Students both surprised and upset.
It's scary. It's weird to think that it's around here, you know. But I guess that's kind of how it always is. It's right under your nose. That's how they operate.
I'm just kind of surprised that at a school with a majority of minority, attendees, that this would happen.
It comes here, and that's like way too close to home, and it's unnecessary.
The college issuing this statement to FiOS 1 News: as an educational institution promoting a safe and supportive environment, Westchester Community College has zero tolerance for hate groups and violence. College bulletin boards are reserved for pre-approved flyers. Per college policy, these flyers have been removed. Now, as we discussed this, Dominic, there's a Jewish guy and a black guy sitting here talking about a white supremacist group.
Isn't that something?
Yeah, we're not. I don't think anybody expects us to take any sort of position. However, I want to take the contrarian in me wants to bring this up. It's a public school. It's a state-run school. There is a freedom of speech issue here. As abhorrent as I find this group and its messaging, I do wonder if they have a right, as a potential student group or as just any group, to spread their message and to try to see if they can attract members. And I'm very conflicted about that because I hate what this group stands for.
Under some situations, I would imagine groups might have a right, but under this case, I don't believe so. It almost amounts to, and I'm not equating them to ISIS, it's almost like ISIS putting up a flyer at a college. It wouldn't last.
Some people would say Black Lives Matter is a violent group. They might call Black Lives Matter a hate group.
You're right. You're 1,000% correct. But in this case, I don't see us in a situation where any college in America is going to permit this to happen.
Some food for thought for people over the weekend. Dominic, thank you very much. As you may know, next month, voters across New York will have the final word on whether the Empire State should hold a constitutional convention, possibly clearing the way to any number of potential changes to the state constitution. New poll from Siena finds New York voters split on the idea, with a plurality saying yes, but plenty are still undecided. What's more, it looks like some voters are confused about the whole thing, with some who call the idea an expensive waste of time, that 45%, apparently still considering voting for a convention, because only 39% say they'd vote no. That confusion is one of the many reasons why on Monday, RFL will re-air our special on what's commonly known as ConCon. We'll have an ardent ConCon supporter squaring off against an ardent ConCon critic. Both will make their cases, so you can decide how to cast your vote next month. We go inside the ConCon again, Monday night at 6, right here on RFL. Up next on this edition of RFL, how some local fire departments are burning through taxpayer cash for things like parties and trips.